Welcome to our first Artese Zandri Coffee Talk. Today, we're talking about why it's important to update your estate plans when you go through a particular life event like separation or divorce, and even before marriage. We have Brit Burner here today, whom we'll introduce in a minute, and I'm also joined by my partner, Lauren Artese, and our operations director, Julie Kauser. Just some quick administrative notes. This coffee talk is scheduled to last about 30 minutes, but we do have some time at the end for Q&A. If you do have questions as we're going through, please feel free to go ahead and chat them to us. Julie will moderate and she will give you some instructions or details on how to do that if you're not familiar with the chat feature on Zoom. We'll try to work those questions into the conversation. If we don't get an opportunity to do that, we will definitely get to them at the end. So about the topic, it may seem obvious at this point, but the reason we're doing this now is because the current pandemic has cast a light on the fact that many of us have had to deal with loss. And we've had to check in with a lot of clients who are in the middle of a separation or divorce and make sure that they've done all they can to protect their estates. So Lauren and I wanted to start our Coffee Talk series with a topic that is very timely and also a bit timeless, because these issues are issues that all of us have to deal with and have to be thinking about throughout our lives as different life events occur. So Lauren, I'd like to just turn it to you to introduce yourself and explain a little more about that.
Morning, everyone. Welcome. So as you can imagine, in what Paige and I deal with, divorces are difficult. It's some of the worst time that people have in their lives. And because of that, I think that they just want to focus on the divorce, get it over with, and move on with their lives. And what we have come to notice is that in doing that, and which is understandable because it's such a traumatic and difficult time for people, they don't think about some other issues that end up resulting in complications down the road for them. So what we thought would be a good idea would be to bring in an attorney that we've known for many years and worked with, who is an expert on estate planning, who has helped us advise clients and guide them and kind of take care of everything. Because when you have a life event, a loss, a separation, a divorce, or even you're getting married, you do need to think about the long-term implications of that event, and wrapping that up isn't always as easy and as simple as people may think it is. So that's why we brought in Brit Burner. So I'd like to turn it over to Brit to kind of give us a basic idea of what types of estate issues to focus on and worry about, or think about during a divorce. So, Brit.
Great, thank you. So I'm Brit Burner. My law firm is Burner Law Group. We have 3 offices, 1 in Manhattan and 2 out on Long Island. And it's our law firm's 25th year. And we are happy to serve our clients in estate planning and trust and estates issues and elder law issues. And a lot of times we have clients that come in who either just went through a divorce or are going through a divorce, or have a child or one of their beneficiaries that's going through a divorce, and they want to know how they can properly handle that and take care of the situation. And so we're happy to work with their matrimonial attorneys, also people starting out their marriages and working with their attorneys in terms of setting up maybe a prenup or a postnup if they've just gotten married. So I'm really happy to be here. Thank you for having me. And I'm excited to have this conversation.
This is exciting for all of us. Thanks so much. I'm so excited to be moderating Artese Zandri's first coffee talk. We've talked for a number of months about doing one of these, and this was a great topic to launch off on. So thank you everybody for joining us. And I think just with that, why don't we just dig in, Brit, right away and talk about why is this so important? Clients, when they have, they need to get their financial house in order, as Lauren talked about, they're so overwhelmed after or during the process that this may get left behind. And, what could potentially happen if down the road, whether it's even soon down the road or way down the road, these documents aren't updated. So maybe you could just kind of give us an overview, a top level overview of why this is such an important topic to make sure they're paying attention to.
Sure. I mean, the most obvious reason is because most people, when they are married, they have a significant other, they have a partner, have named their partner in all of these documents. And we'll go through what all the documents are, but they've named who is going to, I'll go through the last will and testament. They likely have their spouse as executor or trustee of any trust created under the document, also as beneficiary of the document. They likely have named their spouse as their healthcare agent on a healthcare proxy. They've named their spouse as power of attorney over all of their financial documents, financial affairs. They've named their spouse to handle everything for them if they become unable to handle it for themselves because of some kind of disability, or in the case of death, if they're not around, they've named their spouse. And so it's really important that those things are updated. The less obvious answer is we always tell clients your estate planning documents are not a one and done thing. You don't do your estate planning when you're 25 and you buy a house and you have your first child and then you never have to do them again. They have to be updated with change of life circumstances. And certainly changing who your partner is a huge change of life circumstance. It may not just make you change who your number one person is to name for things, but it probably changes a lot of your other relationships as well. And so it's really important to revisit these issues when you are at a point that you're making such a large change in your life.
Yeah, I mean, we know like there's so many different checks and balances too that need to happen. One of the questions just as you were talking that came to mind is, well, first, maybe we could go over the various documents that we need to make sure are updated, because I know occasionally somebody maybe did update their will, but maybe they forgot to update a beneficiary on a 401k plan. And how could that potentially affect something? And so maybe if you could just go through the various documents that people want to make sure that they're remembering to update so everything kind of speaks to one another.
Sure. So obviously the timing of when to do all this is something we can discuss in a few minutes, but the documents I mentioned, the main estate planning documents, a last will and testament, power of attorney, healthcare proxy, and if you have beneficiary designations on any retirement plans, life insurance, anything that has a death benefit, you are going to want to relook at those things. And hopefully your estate planning attorney is looking at all those things wholly as an estate plan and making sure that everything coincides. You never want to just change one thing without taking a look at everything and making sure it all still makes sense. So again, it's just a good time to review everything, take stock, and figure out how you want to move forward as this big change happens.
Right. What challenges do you see clients face if they haven't updated a new will or estate plans? Say they've gotten divorced and maybe they never got around to it. Maybe you could kind of enlighten our viewers. And by the way, actually also anybody who wants to send in a Q&A question, down at the bottom, there's a Q&A. It sends it in to us. Nobody sees what you're sending in. So please feel free. The chat function is disabled. It's the Q&A portion that you can type and send that into. So I'm sorry, Brit. So if you maybe could talk about what happens, what are the challenges that you would be faced with if you hadn't done this?
Sure. So when you are a last will and testament, there's actually a statute that says that if you do get divorced and completed finalized divorce, that your last will and testament is not invalidated, but it's treated as if your prior spouse has predeceased you. So if they're named as beneficiary, it will be deemed as if they predeceased you, and whatever the terms of that document say happens if that person predeceases you will take place. So you may have said, I leave everything to my spouse, but if my spouse predeceases me, then to my children. So in that instance, it would go to your children. In the instance where you say everything goes to my spouse, but if my spouse predeceases me, it goes to charity, then same thing, it would go to charity. So it would be as if that person had predeceased. It would be the same for if they were named as executor. Did you name a successor? This all goes back to how your documents were originally drafted. If you did name a successor, then that person would be the nominated executor. And so that's what happens with the last will and testament. But for the other documents, they are not invalidated by divorce. And so I think that in whether you want to change who you're naming or not, you want to redo the documents. So I'll give an example. I had a client who came in, they had gotten a divorce, but they remained very close. And they were still each other's person, kind of the word I used for it. So that was who they wanted if something happened to them, to make medical decisions, to help with financial decisions, but they decided they could no longer live together and be a married couple. So what I advised them to do was to actually re-sign all the documents post-divorce saying, oh, I still want this person to serve in those functions. Because if they're incapacitated, if they're unable to say that they still want that person, someone could swoop in and say, well, obviously they don't want their ex to be power of attorney anymore. Obviously they don't want their ex to be healthcare agent anymore. And that might still be their wishes. So it's very important that those documents are updated. And then obviously, if you definitely don't want that person anymore, you're going to want to get those documents done so that it's clear who it is that you would want to act, because there is no default in the law for those other documents.
Julie, if you don't mind, can I jump in? I have a follow-up question. Yeah. Because Brit, you had mentioned something in a prior conversation I thought was really relevant here. If we have a client who's going through a divorce and now needs to update their estate plans, you had mentioned something about their other family members also checking in on their wills and beneficiary designations. Can you talk a little bit about that?
Sure, certainly. I mean, we have people all the time who have, let's say the grandparent generation or the parent of the divorcing person who has named their child to be their trustee, their executor, their healthcare agent. And many times they name that child's spouse as the successor. That might be they might live close by, closer than the other children. There might not be other children. It might be a very small nuclear family. And so they've named their child's spouse to be that successor, or even to be the successor beneficiary if something happens to their spouse. So in addition to the divorcing people wanting to make sure that they are getting their documents updated, you're really going to want to make sure that any family members who have included that spouse in their estate planning documents are looking at it and making sure that they have the proper documents fixed if they don't want that person to serve anymore. I think what we were talking about was, you might love your son-in-law or your daughter-in-law until they're divorcing your child, and that love might not be there anymore.
Yeah, no, I think that's a really important point and one that's easy to gloss over.
Yeah. And also, Brit, you had started mentioning where you mentioned about timing. And I think that's something that's very important to both, I think, attorneys who handle estate planning and then also matrimonial and family attorneys who deal with the separation, because we recommend that an estate attorney brought in at the beginning of the life event, not after, if that's possible. And, we think it's because it's better to preemptively work everything out than be trying to correct things after the fact or fix things. Like, how do you feel about that? What's your position on when you want to be brought into a legal matter if there's a separation or a marriage or something of a life-changing event?
Yeah. It's funny. I always tell people that people don't ever want to see their dentist or their lawyers. It's like the two things people try to avoid. And I think when you're going through a divorce, you're going through whether it's a happy divorce or not happy divorce, but whether it's a consenting divorce or a contested divorce, it's not enjoyable, and nobody really wants to be dealing with it. So the last thing they want to do is, now I have to see another lawyer. But, it really is, you guys handle what you handle and you're great at it. And and attorneys that do what I do handle estate planning, and that's what we do. And I think it's important for people to realize that we don't do the same thing. So it's not, oh, I have a lawyer. It's you have a lawyer for a certain item. And so I do think timing wise, it's important that, especially when I have clients who come in who have separation agreements, or they've gone through with the divorce and they say, oh, the lawyers came up with an agreement that I have to put X, Y, and Z in my will. And it might be that that doesn't really make sense in terms of a tax perspective, a state tax perspective, or something like that, a drafting perspective. And so I think it would be helpful if somebody was working on updating their estate planning at the same time as they were going through and coming up with these provisions. But I would always defer back to the matrimonial attorney as to when to effectuate the documents, when to sign them.
Because
I think oh, sorry, go ahead, Paige.
Yeah, I was going to, just as an extension of that, we have this issue that you cannot disinherit your spouse. And, a divorce matter can extend for a long period of time, sometimes several years. And you have that very sort of, we'll call it like a vulnerability during that period, where if God forbid something were to fatally happen to a client, and they're fighting to keep their assets preserved and away from their future ex-partner, that not being able to disinherit your spouse is an interesting law in New York State. And one of the ways that we've thought about that is through, obviously we have agreements like pre-nups and post-nups that we can, hopefully we'll have time to talk about in a little bit. But how would you recommend that a client update their will during that, vulnerability period?
Yeah, so the law that you're referring to is the right of election. So basically, New York says you can't disinherit your spouse. But what does that really mean? What that really means is that if I do disinherit my spouse, people do it all the time. They write a will that says I give everything to my sister, nothing to my spouse. And that is disinheriting your spouse. Your spouse, though, has a 1/3 right of election. So that means that your spouse has the right to go to court and elect to get 1/3 of your estate. So if you have, a $300,000 bank account and you leave it all to your sister, your spouse can go to court, file that right of election. They have to affirmatively assert it. It's not just given to them. And if they do, your sister would have to hand over $100,000 of that $300,000 account, because that is your spouse's right to receive a 1/3 right of election. It's also the same where we have some people who say, I leave everything to my spouse in a trust. But the spouse might not like the terms of the trust. So the spouse has two options. They could take everything that you gave them in a trust, or they could force the 1/3 right of election outright. So they might be giving up some of the money, but they're getting it on their own terms and they're getting it outright. And so that's what that 1/3 right of election is. But it does have to be asserted by the spouse. And many prenups and postnups, actually both spouses waive that right against the other spouse's estate, which is basically saying we're not going to let these default rules take over. We're going to let the estate planning documents that we create and the contracts that we create between us control what happens here in divorce or in death, not the default of the law. So I think that, yeah, go ahead.
If I'm hearing you correctly, it sounds like you can't disinherit your spouse, but your spouse has to make that affirmative election, meaning they would have to actually go to court and file documents. And so what do you recommend the language be in a client's will if they are going to update during the pendency of a divorce?
Sure. So if they're going to update I would defer back to matrimonial attorney if they should in the pendency of the divorce. I think that if it's a tactical decision, right? So you guys on your end, you're in negotiations, you might be in mediation, who knows, this could be in the courts, it could be done privately between the lawyers, but either way, you're trying to come up with a solution to this problem. So I would always say to somebody, listen, I can update your will and I can disinherit your spouse and then I would honestly, if somebody was going to go forward with doing it, I would just flat out disinherit them. But you should find out from your matrimonial attorney if that makes sense tactically, because you might be flaring up anger that's not there, or flaring worsening anger that is there. And that might take, I'm sure, how many times have you guys had somebody walk in your office and say, oh, by the way, I signed a new will and I disinherited my spouse, and you were, this close to an agreement, and everybody goes crazy.
Yeah. Well, we appreciate that you defer to us in that regard. And Lauren, and then Julie, I think a question came in, so I don't mean to overtake.
That's okay. There was a question that came in, but I think we'll circle back around to that in a moment. The question that came in, but one of the questions that actually came to my mind, and maybe it's right or wrong to even ask this, but could a post-nup be served in this case? Could you, instead of rewriting the will for the time being, put a post-nup into place during this separation time?
Yeah, if I could take that, because I can, it depends on the type of case that it is. I mean, if you have a highly contested case, the chances of executing a post-nup, I mean, you might as well just a settlement, or a stipulation if that's the case. And I think there are some limitations in terms of what you can change and what you can't change. And the last will and testament happens to be one of the documents that you can change. But there are also, there's, once a divorce is commenced, it's called the notice of automatic orders. And there's certain orders that the court puts into effect to protect marital assets and things like that. So it can get more complicated. And that's, I think, what Brit was talking about in terms of the estate attorney and the matrimonial attorney need to get on the same page to protect the client, because you don't want to undermine the overall disposition of the case and settling the case because you're angry. And sometimes disinheriting a spouse can come out of an anger. Divorces are very painful. There's a lot of suffering. It's very hard to take the emotion out of it and act practically. But there are also some cases where one of the spouses has a lot of assets and a lot of separate property, and they, ideally you would want to have done a prenup and then have an estate plan line up with that prenup. But there are cases where that doesn't happen. So I think it's an interesting idea. If you have a lot of separate property, family money, and you want to protect that, so you would do, I think under a circumstance like that, you would maybe do a will where you disinherited your spouse and let them assert the election. God forbid you pass away, during the divorce
process. Yeah. So I just want to be mindful of the time, because I do want to transition this. We have about 5 minutes just for the core part of this, and then we'll get onto the Q&A and answer the questions that have come in. But Paige, I think that this is a great segue to kind of talk about, all right, so forget it. Maybe you've been divorced and you're going to get remarried, and now you want to do prenups. How does this work into the estate planning, and where can you guys work together on prenups, or even maybe postnups and estate planning, and how, maybe cover a little bit about how that works?
Yeah, I'll start, and then Brit, if you want to jump in. So, we often work with clients to draft prenups and postnups and that relates to your estate plan for exactly the reason that we were just discussing, which is the mutual waiver of that right of election. And a lot of clients will ask, well, does that mean that I then cannot leave anything to my spouse? And so, Brit, this is usually the part where I would, invite you to join the conversation, where if you waive your right of election in a prenup, your interest that is left to you in your spouse's will supersede that right of election. So if you decide later on that you want to keep your prenup in place, because the prenup, remember, really is an instrument, it's a contract that springs into operation upon divorce, but it also does have an element that's effective upon death. So if you want to preserve the prenup in case, God forbid, the marriage were to fail, and each of you were to survive the divorce, you can do that, then let's say during your lifetime, if you remain married, you do then want to leave everything to your spouse because you've lived a long, happy marriage. You can do that without having to invalidate your prenup. Brit, do you have the same experience? Have you had clients deal with issues like that?
Yeah, I mean, I would say many of my clients, even ones who sign prenups and ones who don't, who end up leaving everything to their spouse, whether it's all to their spouse 100% outright, or there's a trust. You know, a lot of times in a second marriage, they may say, I want everything in a trust for the benefit of my spouse, so my spouse is taken care of. But when my spouse dies, I want the assets to go to my children from my first marriage because I didn't have children with the second spouse. And so I don't want everything then to go to my spouse's family pursuant to my spouse's will. So a lot of times we're doing things like that. The prenup still remains in effect and is really important because what it's saying is my spouse can't force that 1/3 out. My spouse can't go around the terms of my documents, my will or my trust, however I choose to do my estate planning, and force this 1/3. So most clients who have a prenup that's waiving that right of election, again, they're just saying, I want our documents to control, not this default law that gives the 1/3. So I think it's really important.
Yeah, and that's the spirit behind prenups, post-nups, is to be able to take that control and not have the default, you know, legal mechanisms take over for you. And I just want to make one last point. You know, your will is a private document. So what Lauren was talking about, the automatic orders, you know, when you update your will, no one has to see that. And so you don't have to disclose it to your partner when you're going through divorce. But one thing that you can't do, and that is prevented by the automatic orders once a divorce action is commenced, is, you know, a good example that's relevant to this topic is that you cannot change the beneficiary designation on your insurance policies. And I'm pretty sure you can't do that without your spouse's consent anyway, even if the automatic orders weren't in place. So it's just important to remember that there are some documents that are private. There are some laws that are court ordered, and then there are some things that are just private agreements. So, you know, Lauren made the point, you know, if you're going to try and waive your right of election in a post-nup, in order to get that done while you're going through a divorce, you may as well actually go for, you know, negotiating the full settlement agreement. That's a contract. The post-nup is a contract. The prenup is a contract. All that stuff are private agreements that the court cannot force you into. So it's important to think about these things in advance and think about them through the lens of taking control back and really dictating the terms of how your estate, how your assets will be preserved for yourself and for your family members.
Yep, Paige, I want to say on that something that I think is really interesting, and I hit it all the time, and I'm thinking you guys probably get it a lot too, is people think that trusts, for example, are only for the uber rich. And they probably think the same thing about prenups, right? Well, I don't really have anything. Why? And it's what you're talking about. The same with estate planning, the same with prenups. It's about control. It's about making sure that what you want to happen happens the way you want it to happen, and you put the people in place that are going to make those things go the way that you expect. And so this stuff is not necessarily for, or it isn't for the uber rich. There's a place for this matrimonial planning as well as estate planning for everybody, I think.
Yeah, thanks for that point.
Yeah.
I want to make sure we address, because it kind of also talks about what you were just talking about, Paige. We have one participant who sent in a question, and we covered this a little bit at the very beginning, but they've asked, please clarify the importance of reviewing and changing beneficiary designations of life insurance policies, IRA, and 401k. So I don't know who wants to take this.
In terms of once a divorce has been commenced, you can't until there's a court order allowing you to. So that could either be, you know, the settlement agreement may allow you to do it, which is going to become a part of the judgment of divorce, and it's a court order. You can't change beneficiaries, 401ks, pensions, anything like that. And that goes to what Paige, you know, was just talking about in terms of the will is a different instrument, and it gets a little bit more complicated because in terms of divorces, you're talking about marital assets and separate property, and there has to be a determination as to who that property belongs to. When you're dealing with wills, the last will and testament, you're talking about your property and your assets and determining who they're going to go to after you've passed. So it does get a little complicated, and we probably could do a whole nother webinar on marital assets versus separate property that, and so you really can't, once the divorce is commenced, if you have named your spouse as a beneficiary on your pension, on your 401k, on your life insurance, you can't change that until the case has been resolved.
And I'll add to that. So once the case has been resolved, to answer that person's question, it's incredibly important that you make those changes, because there isn't this default that it's invalidated. And the number of times that we've had people come in after someone's death and say, okay, they have life insurance, and we check it, and no one ever changed that beneficiary, and it's going to the ex-spouse that they haven't seen in 30 years. It happens. It happens a lot. So I would say it's important for that reason. It's also important because if it is your spouse and then the default is or the successor, a beneficiary was your minor child, and then now you change that beneficiary designation, it's not just enough to change it to name your children, because you don't want to be naming minors to be the beneficiary on any of these things. You need properly created trusts for the benefit of those minors in your documents. So your will needs to say, I create a trust. If something happens to me, there's a trust for the benefit of my child. That trust, this is who I want to be the trustee. Might not be your sister-in-law who was the trustee on your prior documents. I want to name this person as trustee. These are the terms. And then it's in control, because if you die and your ex-spouse is still alive, they become the guardian of that child, but they don't become the guardian of that child's property, of the child's money, unless they petition the court. And if you have that child named outright, that money is going to go to the child, and the ex-spouse is going to be controlling it. If you do what we're telling you to do, which is create a trust, name a trustee that you want, and then direct those that the beneficiary designations go into that trust, then that person that you've named is controlling the money you're leaving behind to your child, not your ex, and not your whoever your ex involves in their life. And so again, this all goes back to control. So it's really important that you revisit all this post-divorce.
So Brit, that's interesting. And what would be your recommendation in terms of timing? Because a lot of times in divorce, settlements, we will put in that language about the trust. When would you create that trust? But how does that work? Can you explain that?
Sure. So there's really two ways you can create the trust. You can do it right in your last will and testament. So if you have a last will and testament that says, upon my death, everything goes into a trust for the benefit of my child, here are the terms. When your will is probated, that trust is created as part of that. The other option, and I just recently did this with a client who came to me just post-divorce, not during, so I had no say in how it was written, but their divorce agreement said that, I don't even know if I'm using the right word. Is it called a divorce agreement?
Agreement. Yeah, that's fine. Agreement.
Okay. So it said that they have to put aside, create trusts for their children. They had 4 children. They had to create 4 trusts for the 4 children and put X amount of dollars in each trust. I don't know actually how it got to that point, but that was how it was created. And so we actually are now creating those trusts that are freestanding trusts. So they're not within the person's last will and testament. Each child has a trust in their own name. It gets a tax ID number right now. It's created right now, and the money is going to go in that trust. And then what we're getting involved in with the client now is, well, okay, so when a trust earns income, who's getting taxed on that income? Are you getting taxed, or are the kids getting taxed? How can we be most tax efficient with that? These are all probably things that I don't think it's the end of the world that it wasn't discussed prior, but probably should have been a thought, because if these people, this is a very amicable divorce, if it wasn't, these could be things we'd still be fighting about.
I mean, realistically, you could end back up in court on post-divorce actions because of things like that in an uncontested divorce, where where they don't really get along. So, I mean, for us, what we want to do for our clients is make sure that once their divorce is finalized, that future litigation, the possibility of future litigation is limited as much as possible. And that would be why we would want to bring in an estate attorney and talk to them. What's the best way this is what the parties want to accomplish with the trusts. What is the best way to accomplish that? And go through all of what do they have to decide? What do the provisions in terms of the agreement need to be? Are there tax implications going forward? Because you can stipulate to that. That could be more provisions in the divorce agreement that can be decided and prevent future litigation. And that's because for matrimonial attorneys, what they want to do is limit the litigation for the parties as much as possible. And so that's
right.
That's like a perfect example of where your expertise would help us facilitate the best result for our client. And why I think we wanted to do something like this, to talk about all the family issues that kind of intertwine in estate and family matters. So thank you.
We have a couple other questions I want to make sure that we address. First of all, before we answer these, I'm just curious, Brit, are people able to start? I mean, obviously everybody's social distancing right now. You probably maybe aren't even taking in-person appointments, I'm sure, because of this. Are people able to start this process?
Yes, definitely. I do Zoom consultations all the time. It's working very well, actually. And at the moment, we have emergency orders signed by the governor that are allowing us to do remote witnessing and remote notarization. Those are about to expire, but I think we anticipate that they're going to be extended further as we all continue to stay at home, and we need those services to continue that way. It's a little cumbersome because it involves a video conference. It involves then electronically transmitting the documents back after the client signs them. Then it involves the attorney electronically signing those, printing out and signing those, and then electronically sending them back, and then also sending the originals. So there's a lot of steps, but we have been doing it, and it's been working quite well. And Zoom is great, and as are all those other FaceTime. We've used all different ways to connect with clients. So you can certainly start now. And what we found actually is that a lot of people who've been putting this off maybe have a little more time now. And as Lauren was saying at the beginning, it's a little more
house cleaning,
real to people now. It's a little scary, but use your free time to plan for death and disability.
Yeah. Okay, let's dig in on some of these questions. We've got some good ones. We have, first of all, one of our participants says, nice to see you all. I have a 19 and 15-year-old and divorced. Do I need a will only? No trust needed, right?
Well, I think
that is a trick question. Were you going to say something, Lauren? You can go first, and then I'll go.
I think it depends. I mean, I think in order for Brit to answer that, she would need to have, a thorough conversation with you about the your financial circumstances, everything, and the terms of the divorce. I mean, the terms of the divorce are so important, especially when you have minor children, because there is a responsibility of each parent to support financially those children until the children are 21. So, you may need a trust, you may not need a trust, a will may be sufficient, it depends. I mean, I think for parties with children who are under 21, the life insurance issue is more important, because God forbid something in terms of dealing with the minor children, and the financial obligation each parent has to the child at this point. But I mean, I don't think you could answer that, Brit, right, with that. You need more.
Yeah. I mean, I can answer to the extent, I say it's a trick question because I am a lawyer who very strongly believes that every single circumstance is different. So you gave us a little bit of information, but we would need to really dive in and ask a lot more questions. But I will tell you that with a 15-year-old, you do have a minor. And so whether you create a trust for yourself or you create a will, either way, the assets that go to certainly to the minor, but possibly also to the 19-year-old should go in a trust, because a minor cannot take possession of the assets without, again, that other parent becoming the guardian of the property. And there's also tax implications depending on what type of assets you have to giving certain assets to a minor. So probably you need some kind of trust planning, but it may be sufficient for that trust to just be included in your last will and testament.
Okay.
And what is a minor? Sorry, when you say that it's 18 for
18. Yep.
Yeah, it's interesting because there's different ages. Like it's 18 for custody for us, but parents still have the obligation to pay child support through 21 in New York State. I think it varies by state. So yeah, it's interesting, but also, you know, kids are young. So a trust might be something, you know, should a 21-year-old be getting, you know, if you have a large estate that you would be leaving behind, you know, you also, just to protect your child, you might want to consider it. You know,
It sounds like
yeah, certainly. We actually recommend that most people, it used to be that we would say, okay, you give a third at 25, a third at 30, and a third at 35, and the trust pays out to the child. But almost in all situations now, what we actually recommend is a type of trust where the child doesn't ever really get the money fully outright unless it's distributed from the trustee to them, but we more will make them a trustee at a certain age. So your child may become a co-trustee of their trust at 25, they become their own trustee at 30. There's certain rules within the trust depending on how we draft it, but actually that those assets stay in trust. And interestingly, on this topic, is an asset outside of the marriage when your child gets married. And if they then go through a divorce, this asset that you've left them, it has creditor protection if you leave it in trust, even with them as their own trustee, and that could protect it in the case of your child's divorce. So there's a lot of, which is a strange thing to talk about with somebody who has a 15-year-old. You're not really thinking about that happening with your child, but you know, these are the kind of life planning things that we try to do with multi-generational documents and multi-generational planning.
That was a great segue, because we had somebody who had asked what your views were on tiering distributions from trusts to adult children, say 21, 25, and 30. So you guys automatically segue right into that one. I'm going to move on to a question, I think, Paige, that maybe you can address. Somebody has asked, could you consider including life insurance in a prenup as a trade for the 1/3 of election?
Yeah, if you have reluctancy in your negotiations from one side or the other to do an outright waiver of the right of election, you can absolutely use an instrument like life insurance to provide that 1/3 portion of the estate without actually taking assets out of your estate other than those life insurance proceeds. And so that amount, though, will need to be adjusted. I've never been a life insurance broker, but I'm almost positive that you will have to periodically, and I would suggest annually might be a good time, adjust the amount to conform with whatever the value of 1/3 of your estate is. So the amount that you have in your life insurance policy that would go to your spouse if they've made that election or if they've waived that election, the value of your estate fluctuates, you'll have to also update your life insurance policy to reflect that 1/3 value. Brit, is that fair?
Yeah, and interestingly, life insurance proceeds, the death benefit, are not calculated as part of your estate for the right of election calculation. So if it's that $300,000 bank account that I was talking about and a $300,000 death benefit, your spouse is only entitled to 1/3 of that bank account. They're not entitled to a third of the death benefits not coming into the calculation. So it is a nice thing to keep on the side.
Yeah, calculating that share is not always straightforward when you have a difference between testamentary and non-testamentary assets, and that's something that, you know, your expertise is really, you know, critical in making that determination.
And that would,
Yeah. If you have, I mean, an apartment, say you own an apartment, a bank account, an IRA, and life insurance, everything except the life insurance goes in for the right of election, but that, you know, they get a third of that, but not. And then how is it satisfied? You know, you might have had a situation where you owned the property, the apartment joint with right of survivorship, or, you know, tenanted by the entirety because you were married, and that might half of the apartment might more than satisfy the 1/3 if it's a really highly valued apartment, and there might not be any cash because you got the apartment. So, and you were getting the apartment anyway because of the joint nature of it. So it's really depends. It depends how you own your assets and not just the dollar value.
Yeah. So I guess back to, you know, the way lawyers answer every question is that it really does depend on your asset allocation there.
Yeah.
That's why this is all such a personal, all of it is planning, whether it's estate planning or matrimonial planning, it's planning for a reason because everybody's situation is different. We have one other question, and I'll just encourage to our participants, if you have anything else that you really want to make sure that we cover during this, please ping them in because we're probably going to wrap up in a couple minutes. But one last question we have right now is, can you provide perspective on the pros and cons of selecting a personal, for example, friend, family, etc. trustee versus a professional trustee? I think Brit this probably is best for you to answer.
Yeah. So again, the best answer ever, it depends. It's, you know, one question I always ask clients is, are you trying to protect your beneficiary from themselves or from other people? That's number one. So if I want to make sure that there's creditor protection, as I was discussing, and that the assets stay in trust, et cetera, but I trust my child, I'm not trying to protect them from themselves. They don't have any drug issues, any spending, you know, shopping spree, spending issues, et cetera, then I can make them their own trustee, and that's great. If I am really worried that it's a special needs trust because they're disabled, or I'm worried that they have these problems, then I need to name someone else as their trustee. So that's step one. Then who to name, right? So am I going to name the personal trustee, as you called it, or the institutional trustee? Those corporate trustees, first of all, have a minimum usually of how much has to be in the trust for them to take it on. They also don't generally like to be the trustee of trusts that have real property in it. It again, depends on the case, but so if it owns a house or an apartment or something. So you have to think about that. There's also fees. So institutional trustees will have set fees that they want to put in there. They can be higher than the personal trustee. The individual person would get under the statute. So you want to take that into account. And then you want to just take into account, who do you have? You know, who are your people? Do you have anyone who's trustworthy? Or is it creating an uncomfortable situation because you're going to have to name one sibling to be trustee for their other sibling, and they're going to fight, and that's a terrible plan. So we should have an institutional trustee.
Yeah.
But then there's more flexibility with an individual than with a corporate. So these are all your question is answered with questions I would ask to try and get to that answer in your situation.
Yeah, I mean, well, that's what it's about, is getting down to the brass tacks of what's right for you, right? So, So I think that's it for all of our questions. But one of the things I just want to stress to our participants and attendees, Paige and Lauren are both available to answer any questions. If you're not exactly sure what you want to do yet and aren't quite ready to speak to an estate planning attorney, they might be able to help you work through some solutions. But Brit, if the participants here wanted to reach you directly, can you let them know how they can reach you?
Sure. So we have a website, burnerlaw.com. There's a lot of content on there. So I think it's also helpful for people who are just kind of trying, they're not ready to talk to anyone yet, but they want to root around and get some information on their own. You can certainly do that. But in addition, my email address is bburner@burnerlaw.com. So it's my first initial and my last name @burnerlaw.com. Or you could always call our office. Right now, we're obviously not physically in the office, but we check our our voicemails, I think every 15 minutes or something.
Wow.
Really
Okay,
crazy like that. So 212-867-3520, but email is really best because that goes directly to me and I can best answer things. But some people don't love the email thing, so we can always set up a call. And yeah, I'm happy to do, you know, Zoom, phone calls. It's nice to get to really learn about people, to really help them and figure out how their solution can be created.
Yeah, we're going to go ahead and post this recording in the next few days to our website. So I would encourage any of our attendees on the call, if you think whether there's something you want to review again, maybe, or you think there might be somebody else in your life that this is relevant to, you'll be receiving a post wrap-up email, and please feel free to share it. And this is a very important topic. It's always an important topic, as we said at the top of the call, but you know, I think in light of where we are right now in the world, you really don't want to make what can already be a very difficult situation even more difficult by not having the proper plans in place. So that's where I would leave it. Paige and Lauren, is there anything else, or Brit, you guys want to have to say?
I think that's the right place to wrap up. And Brit, thank you so much for joining us. There's some really interesting points you made, and as you got into talking about some of the things you can do with trusts, I actually got pretty excited about how creative you can be. So I hope this was helpful for everyone. Lauren, if you want to add anything, I didn't mean to interrupt, but
No, I mean, I think this was interesting, and I hope everybody enjoyed it and found the topics helpful. And you know, both estate law and family law is just so complex, but it's so important, and it is like what we discussed. It's taking the control and being the decision maker in what happens in your life with your family, and you know, and their future and your future. And I think at a time where we have lost a little bit of control over what's going on, it's nice to take it back, you know, somewhere and do some house cleaning, like, you know, we discussed. So thank you so much, Brit, for joining us. And it was really, just really great. And there's so many other topics I'd love to talk to you about. So we'll
definitely keep it in mind for more stuff.
Yeah. Yeah, I'll just thank you guys for having me. It's fun. I do a lot of webinars, but it's fun to chat and have a little human connection, certainly right now. So it was really fun. I enjoyed it. Thanks for including me.
Thank you all.
For everyone.
All right. Well, everybody take care, be well, stay healthy, and thank you for joining us.
Have a great afternoon.
Bye.
All right. Bye.